There was a date.
My Lord Kakuru said that being an authority, it's okay. No. But anyway, in any case, I'm seeking leave.
No, you make your application first about what the reason I allowed you to make your application is not about authority. First of all, make your application about.
My Lord, the dilemma is some of the authorities.
Make your application.
My application, my Lord.
Yes.
Is under.
Authorities come at the end. Just okay. What is your application?
I'm proceeding under Section 59, A to C of the Evidence Act, and under Order 19, Rule 3, Sub-Rule 1 of the Civil Procedure Rules, to make an application that 2 affidavits be struck out from this record. Those are the affidavits, additional affidavits in reply to my petition. The first affidavit is that of Mr. Keith Muhakanizi, which was
the section of the
59. It is that of Mr. Keith Muhakanizi, which was deposited at Kampala of March 2018. And the second affidavit is that of General David Muhozi, which was deposed at Kampala on 29th March 2018. My Lords, the ground for striking out Mr. Keith Mwakanizi's affidavit is that Mr. Keith Mwakanizi deposed to hearsay information in that affidavit, which is contrary to Section 59 of the Evidence Act, which is clear that evidence must be direct as perceived by the person giving that evidence by his or her own senses. And Order 19, Rule 3.1 says that a party or a deponent, actually it says, affidavit shall be confined to such facts as the deponent is able by his or her own knowledge to prove, except interlocutory applications. My Lords, this petition is not interlocutory applications. Mr. Mkahani's affidavit, first of all, he admitted that he was not in the country at the beginning, around September, and he was on leave in December. But he deposed to matters which occurred in his absence, meaning that under Section 59, there would be no way his senses could perceive those facts he's deposing to. My Lord, that also visits the affidavit of General David Muhozi. General David Muhozi also says clearly that he was never at Parliament. And he says clearly that the only communication he got was a call from the IGP, and that was all. But all that affidavit contains information which he cannot prove by his senses, which he never perceived. My Lord, apart from those two, the statute and the rules, I'm relying on the authority of Court of Appeal. It is Mohindo Rehema versus Winifred Kiza. It is Court of Appeal Election Petition Appeal number 29 of 2011. It was a decision of Mpaji Higaine, a DCJ with concurrency of Nshime and Kasule, justices of Supreme Court. Sorry.
Supreme Court or Court of
Justice of Appeal. My Lords, in that decision, Court said that Order 19, Rule 3 of the Civil Procedure Rules provides that affidavits can only include facts that the deponent is able of his own knowledge to prove, except in international applications. Election petitions are not international applications, and therefore hearsay evidence is not admissible. They said the appellant's two affidavits did not disclose the source of information contained in the polling stations in Kasese on the polling day. She could not have been everywhere at the same place to witness the process. The trial judge properly excluded evidence from the appellant's two affidavits that regarded events which took place in her absence and could not therefore prove of her own knowledge. It's my submission, my lords, that Mr. Keith Mahakanizi and General David Mohozi could not prove the contents of those affidavits by their own knowledge.
Is it everything they said in those affidavits?
My lords, everything.
Including their name?
Except the name and their positions. But their name was not evidence. My lords, I'm aware.
Evidence, whether you can say. I don't want to interrupt you, but...
let me first finish this point, my lord.
You have read to us the authority.
Yes, my lord.
And it says that the High Court judge was correct, exclude.
Yes.
He then said to strike out, exclude. And the issue you are raising came out prominently in Chisabe's versus US 7, the constitutional petition number 1, Supreme Court constitutional petition number 1 of 2001. And the Supreme Court said you can defer, you can remove the hearsay and then disregard it. My suggestion, I'm just why don't you put that in your submissions and say evidence of Mohozi is worthless because paragraph 1, 2, 3, 4 are hearsay. Evidence of Mahakanizi is worthless. Paragraph 1 is hearsay. And then we will make a decision along those submissions.
My lords, thank you. My main prayer is that, in my opinion, the entire affidavits contravene the law and the rules. So my substantive prayer is for it to be struck out. But in the alternative,
throw away the baby and
in the alternative,
the bathing basin.
Especially if you have cross-examined on them, then we look at what is hearsay, we remove it, we look at what is not hearsay, if any.
My lords, I was coming.
So what is your second prayer?
In the alternative, that you sever the hearsay. But again, I'm mindful of the decision of my Lord Kasule in Mudiobola Bed Nasa, 2011, where he held that when a witness comes for cross-examination, that part he speaks when he's in the dock, it remains valid. I'm also mindful of that. So
So, okay, are you withdrawing the application? You see,
no, my lord.
My lord was trying to guide you. I'm not saying you should take whatever we say. Are you then saying, in view of what Justice Kasule said, I will now submit, which would be in line with Justice Kapuro's advice. During submission, I'll point out the areas which should be severed, the areas that can be retained, even outside of what they said in court, because that one you accept cannot be touched.
Yes, I accept.
And yes, let's do that in respect of all the actors, not just
not only those two.
all the actors.
My lords, I don't.
Where you find hearsay, you point it out.
My lords, I have only, I think, 3 affidavits. So I don't know their opinion, but I didn't share.
Okay, so what is your position
So
now?
my position now,
we have guided you.
I think I agree with Honorable Justice Kakuro that in my submissions I will keep on pointing out that this evidence was hearsay, it could not be proved.
So you dropped the application now?
It's not dropping, it's abiding by the judges.
You can't
continue with this in the submission.
Yes. Most obliged.
Because you wanted it in this application. Now you've taken good advice and said, okay, I will raise this during my submissions. Please disregard this provision in the affidavit of so and so.
Thank you, my lord.
So that we don't go ahead with this application.
Thank you, my lord. That's the position.
Thank you. Yes, Mr. Ogalo.
My lords, we are doing issue 6, whether the entire process of conceptualizing, consulting, debating, and enacting the act was inconsistent with and in violation of the Constitution.
How much time do you require for?
My lord, 30 minutes.
30 minutes, fine. Yeah. 30 minutes.
My lord, but it's increment. Well, we are proceeding with the usual principle.
Fine.
Okay.
As long as your learned brothers, I don't see a sister on that side, your learned friends rather, sorry, can take the cue that incremental means addresses on what you've not covered, the principle has not covered. Can be very neat and things would flow.
My Lord, I'll begin with the Article 8K of the Constitution, which imports the directive principles of state policy and are therefore justiciable now. My Lord, those principles require my Lord to interpret the Constitution in line with democratic principles. I submit, my Lord, that one of the democratic principles which this court will take into account is orderly succession of government and peaceful transfer of power. My Lord, I invite your Lordship to follow the decision in the Constitutional Appeal number 1 of 2015, State Kubo, and others but the Attorney General, which is authority number 3 on my list of authorities, where the Supreme Court used the democratic principle of separation of powers to help it interpret the Constitution. My Lords, on orderly succession and peaceful transfer of power, I refer to the affidavit of Professor Sendeva, paragraph 8, 8, and Annex P2. This is at pages 7-90 and 10 and 7-92. And the essence of the findings of that commission was that the people of Uganda want an orderly succession of government, with every president strictly observing the term of office as laid down in the Constitution. My Lord, as pointed out by my Lord Justice Jaborion, although it dealt with the two-term limits, the reasons that advanced the people by the people in respect of the two-term limits are also applicable in the case of age limits. I would also refer your Lordship to the Commission report, which is the authority 11 on my list of authorities. Note that at the page 93, paragraph 547, which is headed democratic governance, I note page 145, but the handwritten is page 12, but printed is page 145. Paragraph 7.51 C, where the people's one of the people's concerns, what the people told the commission, why the people of Uganda were very concerned. One of their concerns is that the behavior of past leaders wishing to stay in power made them excessively power hungry and able to sanction any measure which tended to ensure their security contained. Lord, also invite your lordships to page 320, printed paragraph follow point 3.9, headed orderly succession to government and peaceful transfer of power. And Lord, the people of Uganda want orderly transfer, want orderly succession to government and peaceful transfer of power. In conceptualizing a bill, this principle was not taken into account by the mover of the bill. And my Lord, had he done so, in my humble submission, you would have found that it goes against the very brain of what the people of Uganda want. And my Lord, the history, which my Lord take into account, history of the country, how have our governments handed over power? 1966, the president of the country was attacked, his palace burned down, was sent into exile. 1971, Amin showed his way to power. There was no orderly succession. In 1979, out of the war, Amin himself was also shot out of power. There was no peaceful transfer. He was succeeded by Professor Lure, who my Lord was also unceremoniously removed by his own colleagues against their instruments, their own motion instruments.
Did they use the law? They used the law to remove Professor Lure?
My Lord, there was some agreement they had in motion.
Actually, there was a constitutional petition brought by Semogere and Kaira.
Yes.
And the constitutional court said the removal of Lure was unconstitutional, but they stopped that because of the Kelsim theory of
Successful revolution.
Most obliged, my Lord. So, my Lord, you will have a decision of your court saying that move was unconstitutional. They placed their president in eyes. He was never given a chance to hand over power to the next president. They also removed him.
He ended the presidency under house arrest.
The best he said he didn't want to go because the chair was.
Yes, my Lord, he said they were commenting, and it's not just the sweetness of the seat, but also, my Lord, that the military commission simply threw him out and assumed the power. Then he came in for 42. Then he did Othello shot his way into power, removed the 42. No orderly transfer of power. No peaceful transfer.
Wasn't there a transfer from the military commission to Milton Obote in 1980? 81, early 81, I think 1980. 80. Wasn't there a peaceful transfer from the military commission, Paulo Mwanga, Yoweri Museveni, and somebody else?
Yes, my lord.
Then Milton Obote was sworn in front of Parliament.
Yes, my lord. But
that was an exception to the rule.
No, because how the electoral commission itself came into power. What was this handing over?
The argument was that Paulo Mwanga was holding the government by proxy. It was because the moment Obote was sworn in, he also saw Mwanga in as his fight.
As a reward.
Yes. My lord, all that put into question that he had that this would run back power. All that he can arrange the thing. This is our thing, this is how we handle it.
Okay. Yes. Proceed, yes.
My lord, as I was saying in 85, Okello shoots himself into power. No peaceful transfer.
Somebody has said Obote was not overthrown in 1985. This government simply imploded.
No, my lord.
Just collapsed, and there was space, and for your good and mine, somebody had to be there.
No, my lord. What happened is that there was a military coup. Soldiers moved in from Gulu. They came to Kampala. They brought the president. What followed later does not take away the fact that there was a queen who died.
Okay.
So the BBC reported that Obote, for the second time in 14 years, has been overthrown by his own army and has again fled in exile.
Yes, my lord.
Twice, two in 14 years,
yes,
the army overthrowing the same president.
Yes.
The same president being into exile in a state of 14 years.
Yes, my lord, and this is why the quest for peaceful transfer of power is very, very critical in this time. Because if we do not achieve it, that will continue. Then in 1986, my lord, His Excellency President Museveni also shot himself into power. There was no transfer, a peaceful transfer.
He will tell you that he did not. He will say the people in Uganda took power by forceful means. It was a people's revolution, people's resentment to the status quo then obtaining.
Yes, my lord.
He was just one among many peasant players.
Not understanding what anybody can describe it as.
It was not a peaceful transfer.
It was not a peaceful transfer.
Oh, proceed. Proceed, yeah.
So my lord, this history, this principle of orderly succession of government and the peaceful transfer of power is negated by this bill, by this act now, but it removes that possibility.
I thought the purpose was to prolong the peace since 1986. No violent transfer had taken place. And the bill intends to continue that
was it 1989? There was a transfer of power by the NCC from the Bush NCC now. That was peaceful. Then 1996, there was transfer of power from the broad-based pre-1995 constitution to a new team, post-1995 constitution. Then 2001, there was transfer of power from the president elected in 1996 to the president elected in 2001, and so on and so forth. So why do you say there is no peaceful transfer of power?
My lord is the first to answer the first one from 1986. We have all this peace. So what the act is doing is simply extend the peace. My lord, in my humble submission, once you have unrestrained power, however good it is unrestrained, coupled together with the incumbency, the advantages of incumbency, you tend to continue on and on. And therefore, the risk is that you can easily go back to the disorderly transfer of power. So the fact that there is peace now is not a guarantee that tomorrow there will be peace.
This transfer of power necessarily peace in view of what has happened in many places where...
No, my Lord. My Lord, it doesn't necessarily.
I think the first example is Cameroon. Before coming into power for here, he came into power through an election. And since then he has refused. In fact, the person who handed him power, I forget his name, he imprisoned him. And he has not...
He thanked him by imprisoning him.
You are asking that there should be peaceful transfer of power and succession. And this would be through election, not so. How would you transfer power?
No, I'm looking at it in terms of our history, my Lord.
Yes.
The history I have cited. And that also comes out from the people's concern. They were also concerned about
how would the peaceful succession be ensured?
One, by respect, by people respecting the limits in the Constitution. By respecting the limits in the Constitution, you definitely guarantee peace. Because once the Constitution says 75 years you go, after 75 years you have had much something. That might guarantee us peaceful transfer.
But through an election?
Yes, through an election.
So wouldn't you wish that first you have proper free and fair elections before you talk of this?
No, my Lord, those are different things. That period I have been describing, my Lord, the majority of it, there was not even any election. But there was transfer of power violently.
That is why my Lord is asking you, isn't it more important to ensure free and fair election? Because when there is free and fair election, where the ground is, you don't even have to level it because it is already level. You find the ground which is leveled already. It is not level at the time of election. You just go like when you are going to Nambole. You don't go with the handhold right to. It's already level. You go and do your best. Isn't it more important than this one of put limits here, put limits there?
No, with respect to my Lord, it is not, because as you will see from the affidavit and the next that Professor Senteva, he talks about the problems of incumbency, using incumbency to ensure that you win the election.
But there's no empirical evidence for that. The longest serving the head of state is the Queen of England. She was queen when children were born. There was no election. His son, his grandson are born. It depends on the political structure. And that's the issue of election. But the people who run the country, members of parliament, the presidential power. And my issue of this one is the United States. The opposition, having failed to win an election, we are praying to God and to the Constitution that a law removes the president whom they have failed to defeat in an election. Why don't they defeat him? My Lord, once they defeat him, whether there is a clause of 75 or there is no clause of 75, that is the end of the issue.
My Lord, that is exactly what Professor Senteva says in his evidence. Yes. The advantages of incumbency. You can cover, for example, my Lord, let me give this example. There are 140 districts in Uganda. you give, let's say, 120 days for presidential candidates to campaign. The incumbent can cover all of them by using the incumbent helicopter and be in one district every day. Because he has that the facility.
Yes, the helicopter. There was a presidential candidate called a word for word.
Yes,
he brought a helicopter. I don't know what happened. Even Mukula.
My lord, he brought the helicopter, but he never flew.
Because he was not an incumbent.
I know you come from that area. Don't give evidence from the far.
Mr. Gallo, Mr. Wandera Gallo,
Yes, my lord.
as recently as a few years ago, about 5, President Goodluck Jonathan, an incumbent,
Yes.
President Goodluck Jonathan
Yes.
of the Federal Republic of Nigeria, an incumbent, lost the election.
Yes.
I mean, can be done. And there are other reasons, other examples.
In Ghana,
Yes,
the opposition won. And the government went to court that elections had been rigged. The opposition had rigged the elections and they had rigged themselves into power.
Yes, my lord.
I don't know what happened to that petition, but at least they had the power to the opposition and went to court to complain that the opposition had rigged the elections.
and then do not look at the incumbency of the individual. Also look at the incumbency of a political party. Like Kano, yes. Kano was in power since independence. But it was defeated in an election. Same with UNIP, I think UNIP of Kaunda in Zambia. It was defeated by the opposition, and so on and so forth. Meaning even a structure which is very strong can be dismantled as long as there is a properly laid down playing ground. It can be dismantled.
My lord,
In India, the Indian Intra-Gandhi Congress was started by Nehru, his father. And was power for a long time. He died, the son became prime minister. They were defeated.
Yes, my lord. Which now brings me to the point brought by Justice Tebon about elections. If you can then guarantee that, notwithstanding the advantages of incumbents, that you can still have a free and fair election, maybe then you'd have gone a long way in ensuring that you have peaceful transfer of power. But my lord, as our history shows, we are still grappling with that. We are still grappling with whether elections are free or not, which is shown by presidential petitions, my lord. The one of 201, 322. They were saying the election ought to be unfair. That was very narrow. It showed that there was something fundamentally flawed with our electoral process. The petition of 206, presidential, 3 to 4, again very narrow, showing that our process, our electoral process, still had some problems. So in answer to my lord, we can't place all our eggs in that basket because we are still grappling with the electoral process. We have not yet perfected this. That's why.
Go to the next point. That's on your page.
Okay. My lord, my lord, I will just sum up this to say that by failing to take into account our history and this principle which I have laid out, that it was inconsistent with Article 8A of the Constitution, which requires this which requires us to consider these principles. My Lord, the next I wish my Lord to refer to you paragraphs, the affidavit of Francis Gemara, paragraphs 5, 7, 8, 11, 12, 16, 17, 19, para 5, 7, 8 to 11, that is 8 to 11, 12, 16, 17, 19, 27, and 28. And then the affidavit of Professor St. Pepper, paragraphs 5, 6, 7, 8F, and Q, and then the affidavit of Professor Okenga Latiko, paragraphs 34, 42, 43, and 47. And my lords, the thrust of my argument in relying on this evidence is that the Speaker recognized the importance of this bill.
My Lords, I am at pains to appreciate the submissions of my learned friend. To the best of my recollection, my best issue, he said he is addressing your lordships on issue number 6. I don't know whether this is a rejoinder. I don't know whether he's reopening the issue, because this issue was canvassed. Is he rejoining? Is he
number 6?
Yes, it
issue
was.
Number 6?
Yes. I don't know which issue is addressing.
I think it was 6G.
He said issue number 6.
No, it was 6G. Yes. You know, there is 6, and we complain about the drafting of the issue. It was 6, and then it split. It has got A up to G. Come again.
G, my lords, was the basic structure, which also was canvassed by Council for the Petitioners.
No, Learned Attorney General, in part, yes, you are right. Some of the things Learned Counsel is saying had already been mentioned, and use your own word covered, when he was making the introductory, each side made the introductory statement. This, I remember you covered this, even you responded. But there is issue number 6, coached in the terms you can see, with sub-issues A to G, to G, to G. And I remember 6G was covered, and B, and B? And B. Oh, I didn't mark it, so I can't. My lords, we didn't cover B. Only we covered 6A and 6G. Because B required evidence. We covered 6A and 6G.
There's no evidence required.
So A was covered. I remember G was covered. I marked it. So it would still be within his right in covering 6, the head paragraph or the head issue to submit in the manner submitted.
My Lord.
What I can say though, you know, he could have said
on the issue of this in my introductory remark. I covered it, I still maintain the same, something like this, but otherwise, you can still bring it up.
I thought you are just trying to give us another preamble. You have not touched any of the issues. May you proceed with the issues?
Yes, but my Lord, before I do so, when in my introductory remarks, I referred to 8A in respect of a different principle of democracy. Our talk of rule of law. Very different from this. That is what is applicable in issues 1 to 4. In respect of this one, I'm talking about peaceful transfer of power. A different principle.
When is that? There's something like peaceful transfer of power.
My Lord, in 8, I'm relying on 8A.
8 or 6?
Article 8A, which you will find in the body of 6. There is Article 8A.
The only problem, Mr. Bello, the only problem is the key words. I don't know, words. In 6, you're challenging the conceptualizing, the process of consultation, and then the debate in Parliament, which preceded the enactment, or which led to the enactment. You're saying they were not. You're challenging. You're asking whether they were consistent or not, contravened or not, articles of the Constitution as hereunder. Then,
let's proceed.
Then we don't know whether you're the ones going to deal with
my Lord,
B, C, D, or somebody else.
My Lord, then I will leave 8A. I'll finish with the 8A. Article 8A. Now, my Lord, the evidence I talked about is now in the question of Article 1, sovereignty.
Okay.
My Lord, the Speaker invoked sovereignty of the people. She did so at page 47, 46 of the Hansard attached to the affidavit of Kibiriki. And he made it very clear that the people are central to the issue and it cannot be decided without the population. Once she did that, my Lord, it's my humble submission that once they embark on the process of consultation, then that process has to be as clean as the whistle. That once they say yes, we are going to consult with the people, then they must do it very, very properly. And my humble submission that they did not, that they failed to do so. My Lord, the process of participation, was not structured whatsoever. It was left to each individual to decide how to do how have the participation. There was the bill was not circulated to the people. No notice was given that members of parliament are coming for public participation. Therefore, no dates were given to enable people know the places where they were going to meet.
Where do you get all this information that the bill was not circulated, it was not done?
In the way, yes, my Lord. In the supplementary affidavit of Ogenda.
My Lord,
NTV, turning on your world.
Prudential, with over 170 years of existence.